Confidentiality and non-disclosure. I get asked a lot about confidentiality and non-disclosure. And I've made it a habit of putting it into my business contracts because at the end of the day, what a confidentiality and non-disclosure part of a contract does is it protects what the law calls a legitimate business interest. A legitimate business interest is like your trade secret, how you run your business, something that's very specific to your business that you wouldn't want to be out there for a competitor to know or
Right.
someone to take and run their business in a very similar way. So, confidentiality and non disclosure agreements protect legitimate business interests. If you don't have a legitimate business interest, you don't have anything to protect. I don't want businesses just to write it in because they want to write it in and because it sounds nice to say that you're under a confidentiality. It has to protect something and it has to protect your legitimate business interest or your trade secret. Another thing that you want to consider is that you have to put in that part, in the confidentiality and non-disclosure part, what is it that you're identifying as a confidential information? It can't be everything. So you can't say, everything is confidential within this business. That's not necessarily how it's done, and that probably wouldn't be a proper clause anyway. What you would have to do is put specifically what's unique and important to your business. A lot of times you'll put, for example, price lists, right? A price list for your business or your customer list or your procedure of doing something or your work products. Those are the types of things that can be considered confidential and worth protection. So for your business, if it's a legitimate business interest, you put together confidentiality and non-disclosure of the things that you do want to protect and deem confidential. Now, let's say someone takes it anyway. I take your price list, your customer list, I take whatever I want to take and I go ahead and I start my own business or I literally take it to the competitors and decide to work there. What can you do? You can sue. You can definitely sue for a breach, but you will have to prove that, first of all, like with any other lawsuit, you have to prove. One of the things that I always suggest when it comes to a confidentiality breach is for clients to put in what's called a liquidated damages clause. Liquidated damages. Now, liquidated damages is a device that's used or damages for something that's not quantifiable, meaning you can't put an exact price on it. So if someone takes, for example, your price list and your customer list and they go to another company and you sue them, what is it? How much of it are you suing them for? What is that number that you're going to put in your lawsuit? You don't know. You don't really know how much damage that's going to cost you. It could be anything really, but you have to put a number in when you're filing a lawsuit. You have to put an amount. So if you don't know what that number is going to be and it's not quantifiable, that's where the liquidated damages comes in because you can put an amount per violation. So for example, if you say I want my liquidated damages to be $10,000 per violation, then when you do take them to court for breach of this confidentiality and you can prove there's a violation of this, that, and that, like three different things, then your liquidated damages is times three because
So,
you do it per violation. The content on Mind in Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.